Greetings of the day, everyone. How are you all? Hope you all are doing good. Our today's topic is Paper 2, Principles and Practices of Banking, and we will look at the chapter 18, Duties and Rights of a Banker and Customer Rights. We will see few topics under this chapter. Duties of secrecy and confidentiality. As we all know, it's bank's duty to keep all the records and the information of the customer very secret and confidential. The banker-customer relation is a contractual relationship with an implied obligation to keep the affairs of the customers secret and confidential. However, sometimes the banks have to disclose the information. Under certain circumstances, we will see under what circumstances the information can be disclosed or has to be disclosed by the bank. First, legally permissible compulsions, that is, disclosure is under compulsion of law. At times it's happened that due to few statutory obligations, the bank has to disclose the records or any kind of information that is sought from the statutory organizations. Like bankers, first is Bankers Book Evidence Act. Suppose there is a customer, a bank's customer, and it is having a dispute with a third party. In those cases, at times, details are asked from the bank and bank has to produce all the records to the said concerned authority. The records can be in the form of certified copies. The bank doesn't need to submit the original copies. However, the bank has to ascertain that whoever is asking for this kind of data is authorized to do so. Second, summons by civil and criminal courts. In case of criminals or some kind of civil suits, a bank is often asked to disclose some kind of information and give some confidential data. The bank has to abide by the same. Third, Income Tax Act 1961. You might have seen even in the banks, sometimes the income tax officers visit with the attachment order or asking for some kind of account statement. In all those cases, the bank has to either release the payment from the account immediately to the income tax offices or mark a lien in the bank's account, or it has to provide the customer account statement as soon as it is asked for. This also comes under statutory duties of the bank. Other acts, that is Companies Act, RBI Act, FEMA Act, etc. It happens that under all these acts, the bank is made compulsory to disclose all the information to the governing bodies. Second, duty to disclose in public interest. So, suppose a customer of the bank is engaged in some kind of terrorism activities or illegal drug trafficking or some serious anti-national and anti-social activities. In all those cases, the bank has to reveal some kind of information that is good for the public interest. Third, disclosure in the interest of bank. So at times it happens that the bank shares certain information because it has to do so. It comes under its functions. Example, now suppose there is a customer who is not repaying the dues on time and the bank wants to send a notice to the customer providing the details of the same. This is done through advocate and it is a legal notice. In that case, the bank provides account statement to the advocate showing all the repayment schedule and overdue, principal, interest amount, etc. so that the advocates can send a legal notice to the customer. Second is co-bankers. It is in the interest of the bank to share the details with co-bankers. When does this happen? So at times there are few finances like in multiple banking arrangements or consortium banking arrangements. The banks have to share information with each other. All the member banks of the consortium, they share the accounts information, that is the conduct of the account and the operations of the account, on a quarterly or half yearly basis. This is by the rule. Third is credit information companies. As we know, all the banks are the members of few credit information companies like CIBIL, Equifax, etc. The bankers disclose all the information of the accounts to the CIBIL and Equifax. Only then they will be capable to give us a CIBIL report, right? So the banker reveals all the information to them. Fourth is disclosure with expressed or implied consent of customer. If the customer asks the bank to do so, the bank will divulge the information. Next, duty of reasonable care. Banks acts as a trustee they have to exercise reasonable care. Like in case of negligence, the customer can ask for or can claim the damages from the bank. It becomes the bank's responsibility to take care of all the belongings or all the information or the records of the customers. Next, we will study about garnishee order or attachment order. A debtor who owes the money is called a garnisher. Garnishee. In our case, the customer deposits fund with the banks, so bank is a garnishee. So often, court orders or garnishee orders come to the banks, and banks have to stop all the drawings in the account. Alternatively, it also credits the attachment amount from the account. It can park the attachment amount to the sundry account of a office account, or it can directly make the payment to the concerned authorities. Always remember that orders like garnishee orders or attachment orders, if they are in the single names, they do not apply to joint accounts. And if the orders are in the joint names, then every single account of every individual in that joint capacity are to be marked lien. Termination of bank customer relationship. When does a bank and customer relationship terminate? So first is voluntary termination and other is termination by law. What is voluntary termination? First is customer's request. If the customer comes to the bank and says that I want to close the account, the bank will close the account and the contract will come to an end. Or sometimes it becomes the bank's decision to close the account. When does this happen? At times many customers are non-cooperative. They don't provide the information. They don't provide few KYC or other documents. The bank waits for some time. After giving due notice to the customer, the bank closes the account. Second scenario is termination by law. First is death of a customer. In case of death of a customer, and as soon as the bank comes to know about it, the bank has to close the account. But when? After giving the credit balance of the entire account to the nominee of the account, or whatever the rule is there, like obtaining all the KYC documents related to the documentation of inheritance and everything, the bank has to close the account of the deceased customer. Second, bankruptcy of a customer or liquidation of the company. Suppose it comes to the bank notice that a customer has gone bankrupt or a company is being liquidated. Of course, these are very, very long procedures and require a lot of protocols to be followed. However, in short, we can say that once the bank becomes aware about this, it immediately stops the drawings in the account. It keeps the credit balance with itself. After giving all the amount of credit balance to the liquidator and whatever the amount they are asking for, the bank credits it into the liquidator's account and then closes the account. Third, garnishee order. Like we have already discussed, in case of garnishee orders or in case of attachment orders, after giving the proceedings to the concerned authorities, the bank closes the accounts. Insanity of the customer. Few customers, like we know, even as per Contract Act, insane customer or mentally challenged customer, especially mentally challenged customer or insane customers, cannot enter into a contract. If it is proved or if it comes to the bank's notice that the customer is insane, then after verifying with the medical reports, it can close the accounts and terminate the contract. Next, we will study about bank's rights. What are the bank's rights? First is bank's lien. The bank has the right to lien on the assets. What are the assets? So the assets are those against which the bank has granted the finance. Like example, we can talk about FDOD. When a bank grants overdraft facility against the fixed deposits, it marks lien on the deposit on that particular amount of the overdraft. And also, like, we execute lien agreement or security document while giving the FDOD to the customer. Second, right to set off. Suppose there is some loan account and there are a lot of overdues in the account. The customer is not cooperating and not clearing the overdue. If the bank gets to know that one of the savings account in some other branch, or in the branch itself is having credit balance in the account, then the bank can adjust the credit in the savings account with a debit or the overdue debit in the loan account. This comes under right to set off. Third, right of appropriation of accounts. That is, the bank has a right to adjust the overdue amount with proportionate adjustment in the principal as well as the interest amount. It becomes on the bank's discretion. Fourth, right to charge interest or commission. It is the banker's right, or it is the bank's right to charge interest on loans and commission on services, that is the ancillary services like making of a DD or RTGS or NEFT, and on the non-fund based facilities, because commission is charged in case of non-fund based facilities. Next topic is BCSBI, that is the Banking Codes and Standards Boards of India. Why was it established? We are aware, right, that many times our top management or our regional offices often tell us that you have to follow the BCSBI guidelines. There should be a notice board, there should be a complaint register and everything. So why is it that all the banks have to follow the BCSBI rules, and BCSBI at regular intervals, it often comes out with the rankings of the bank that who are following those rules. So what is the main intention of BCSBI? It is promoting good banking practices, setting service standards and increasing the transparency. Basically, it is all in the favor of the customer. It wants that the bank provide good services to the customer and the customer is never deprived of any kind of good service. It has two ideas basically. It is for the commitment to the customers and commitment to micro and small enterprises. Commitment to customers. It is about banks' commitment to provide the bare minimum standards of the service to the individual and takes care that the customer is satisfied with the bank service while banking with it. Second is commitment to micro and small enterprises. This particular clause provides protection to the micro and small enterprises. That is, these are the small manufacturing and service industry outlets that are basically into banking, but again, because they are not big corporate giants, their financial literacy or their awareness regarding banking is not very high. So this is for their protection. How does the BCSBI code help? Then it helps. The codes are set in such a way that the bank has to disclose and explain all kind of terms and conditions or give all kind of information to these small enterprises so that they are aware of everything in their account. This is about transparency in interest rate. Like bank has to explain that these are the interest rates, when will it change, what are the conditions when it can change, the tariff schedule, the processing charges, and the marketing and sales by the banks, etc. Well, that's all for today. Do share, like, and subscribe.